Hello and welcome to Real Estate Today. I'm Laura Harbison, broker-owner of Realty Executive Southern Nevada Properties, and I'm your host. And today I am here with Kerstan Hubbs of Essential Legal Services. And we are going to talk about a situation in which somebody owns a property with someone that they're not related to. It's not their spouse. It's not, not a family member. And now they have a dispute because one person wants the house sold and somebody else, and the other person doesn't. So, Kerstan, what would someone do in that case?
So there is a process. We mentioned it very briefly, I think, a while back when we were talking. It is called the partition process. Again, this is for individuals who are not married, but are co-owners of real property. This is where you're going to see the joint tenancy in common, and then tenancy in common and joint tenancy. And these individuals will have differences in the way they want to use the property, whether they want to sell the property, and how they want to manage it in general. So what will happen is usually the person who is interested in taking action will file the action. It will be a civil lawsuit. It's an equitable relief under NRS 39. And that lawsuit will notify a lot of individuals, again, similar to what we talked about with quiet title actions. We're going to have to get all of the lien holders on the property, everyone that has a property interest in it, in terms of ownership, and file that in court to start the process. During that process, similar to a quiet title action, a partition action requires a notice of lease pendants to be recorded. That puts third parties on notice that there is a dispute about the title and the property in general, and to have knowledge of that before any third parties want to look at this property for purchase.
Right. So they put that cloud on the title, which when a title company pulls a title report, they would see that.
Right. It is a
public record,
an intentional cloud that's put on there. And then once the court has the parties in front of it, they will start to look at potential remedies or relief that they can afford the parties. The first type of partition is similar to the name. You can sometimes have vacant land of some nature that can be literally apportioned up, surveyed, subdivided. Somebody takes 60% if they're 60% owner, and the other one takes 40% of that land, and they put a new survey boundary around it, and they both walk off, and they can do whatever they want with their property. Most of the partition actions will include a situation in which the court will have to force the sale of the property, because it may be a residence that you can't survey and divide up, right? It's a home in which individuals reside,
or a lot that cannot be subdivided, or that it would substantially decrease the value of the property to subdivide it.
Right, correct. So when we start the process, the parties will come to the table. We will again look at the recorded instruments on the property to see who holds what type of interest.
Yeah, what their interest percentages are, that type of thing.
Right. And the court will do a blend. It will apply NRS 39 in terms of the proceeds of that sale. So it will first pay off the cost for filing the partition action, the ancillary third-party costs that come into play, like surveyors or appraisers who need to be part of this action to bring information to the court. And then it will also need to pay off the attorney's fees, typically for the party that had to initiate it. If they were the prevailing party, the individuals who are blocking the sale will typically have to come out of pocket for that. But that is the judge may award, but it is typically awarded. I've seen it in my practice. And then the residue amount will be divided up in the ratio that needs to be divided up between the owners.
Good. Very good.
Okay. But there are some, like I said, equitable remedies that come into play that are important. And sometimes clients get confused because they say, oh my gosh, my cousin has stayed in that house for 6 years and they pay this measly little mortgage that we took out, and I've lived over here and I think they should have to reimburse me, or I have more of an ownership interest because of these things that my cousin did while being in the property.
Because that person got the benefit of living in the property at a reduced cost
Right.
through that period.
But the court, strangely, will say, notwithstanding the fact if there's ouster, which is the other co-owner pushed you out of the property and wouldn't let you stay there, if that's absent and the possession of the property is not adverse,
Right, it was voluntary.
right, then actually each owner was responsible for making the same type of payments on the mortgage. And you can't go after the co-tenant who occupied the home for rent.
Okay, for back rent from the time, because now you're grumpy with them.
Yeah, now you're grumpy, and it's 6 years later, and you're thinking of all the ways you've been slighted. That will not be one avenue that's remedied that way. We can also have some case law that comes into play where we can rebut presumptions. Like I stated, anything in the deed typically will be followed. We'll have a presumption that that's how the property was divided. But if you are not familial in nature with the other co-tenant, and if there is no donative intent, meaning you wasn't a gift, evidence that you were trying to gift that person something, you can rebut the presumption and show that you somehow have a higher percentage of ownership over time based on your contributions toward the property.
Okay. So how could they avoid this dispute? Because I do see a lot of people that are not related, whether it's boyfriend and girlfriend or it's friends, thinking, oh, we're going to buy this investment property together, that purchase properties together. How should they approach that?
There are several different types of individuals who will do this. Obviously, an agreement in writing is a very good way to avoid these mysterious deposits toward real property and what they mean in terms of your ownership over time. As you mentioned, one of the lawsuits that tend to come up to the surface are individuals who are boyfriend, girlfriend. They are cohabitating, and they've never really come up with any type of an arrangement because they were in love, right? And
it was
part of this endeavor, somehow it doesn't work out. We can do cohabitation agreements. Parties in intimate relationships can contract, and those contracts will be honored in court. And so one of the recommendations I have often for individuals is to do a cohabitation agreement if you're going to move in with your significant other. I've seen some other situations that come into play with partitions. I've had individuals who were trying to help their family financially purchase the home.
Right.
Maybe they helped them get the mortgage, and that family member was supposed to refinance over time, and time goes on, and they just are not able to obtain that refinancing option, and the other individual co-tenant wants to...
They want their credit freed up.
Right. They want to get their funds out.
I agreed I would do this for 2 years, and now it's been 5.
Right. We've also seen cases with inheritance where you have maybe a deed upon death conveyance of that nature, and one of the children, say it's to all their children, there's 4 or 5 of them, and then one of them is residing in the premise and they refuse to leave, right? Based on their parents' death. So they want to stay there for whatever reason.
Right.
So this often comes up. Those are more difficult to remedy because it's really just obstinacy. And when you do partition action in and of itself, it doesn't matter. They have as a matter of right, a co-tenant can always bring that action and it can be granted. It doesn't matter if it's inconvenient for one party. Does that make sense?
Right. Yes,
so as a matter of right, it's pretty easy to move through the court to get all the parties into the action and then do a motion for summary judgment saying as a matter of right, here we are, this is due, and they're often granted that way.
Right.
But the hardship about a partition is they're emotionally exhausting. Usually they're close relationships, sometimes family,
very emotional,
friends. They oftentimes it can be a home of a family member, like I stated, mom's old cabin that I don't want to get rid of. And the rest of the family is saying, yes, we are getting rid of the cabin, and everyone's upset. It's going to cost a lot of money, and it will take a lot of time. So those are the issues with a partition, but there is relief at the end of the day if you reach that end. Always during the partition action, you can settle, and one of the ways the court will help you settle is by ordering an appraisal from a neutral party to come up with the amount if one of the individuals want to buy out.
And do a buyout.
Exactly. Right. Yes. Exactly.
Yes, and I've seen that. And I've seen that a lot with multiple, one sibling's living in the property, multiple siblings inherit the property, sibling that's been living there wants to stay, so
that's
if they can buy them out, but a lot of the time that can't. It doesn't work out, but it is, it's good for people to plan ahead for such things.
It definitely is.
Well, thank you for joining us on Real Estate Today. This has been Kerstan Hubbs of Essential Legal Services. If you have any questions, definitely look her up and give her a call. And I'm Laura Harbison, Realty Executives Broker Owner, and I am happy to help with any of your real estate questions as well. So see our information below and give us a call anytime.
Thank you.